cases we told you about was the multi-financial securities versus Brown. To what extent are non-customers, to what extent are brokerage firms, required to submit disputes in arbitration with people who aren't actually their customers, people that don't even have accounts at the brokerage firm?
Can you give an example?
And I'm going to give you an example. In Brown, for example, Mrs. Brown lived in Philadelphia. She was a nurse. She still is a nurse. She was sold unregistered securities by a gentleman who was associated with a brokerage firm called Multi-Financial. Now, this person had letterhead that said Multi-Financial on it. He had business cards that said Multi-Financial on it, member NASD, SIPC. And this gentleman, at least was as alleged, as contained in the Court of Public Records, engaged in the sale of unregistered securities in violation of Section 5 of the 33 Act, sold securities, and there was no effective registration statement under federal law. There was no state blue sky. It was illegal. It's actually a crime to sell unregistered securities. Well, our nurse, she didn't know she was buying securities that were unregistered. She thought she was buying stock in Microsoft because she didn't understand that the securities that she was being sold were actually unregistered and that it was illegal. Of course, the securities turned out to be worthless. It was a giant international Ponzi scheme. Now, because the broker held themselves out as being an agent of Multi, meantime, poor Mrs. Brown, she didn't have a brokerage account with Multi. She didn't have the traditional account where you buy and sell securities. She had no account whatsoever with Multi-Financial, other than the people who she was doing business with, the broker who sold her these securities. Now, we all know that, number one, under 20(a) of the Exchange Act, there's a thing called control person liability, that the broker-dealer is responsible for the acts, the controlled person is responsible for the control person is responsible for the acts of the controlled person, in this case would be the broker. We also have apparent authority, because Mrs. Brown thought she was actually dealing with the broker-dealer. If the defendant went and remodeled her kitchen and did so fraudulently, we wouldn't be suing Multi-Financial, because that's arguably not within the course and scope of what services they provide. But because she bought investments, they sell investments, they're holding themselves out as agents of Multi, we brought an action in arbitration against Multi. Well, you know, the mail comes and I get this big motion, it's an injunction. The other side is enjoining me and saying, no, 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 you can't go to arbitration. She's not a public customer. When we agreed to become members of the NASD, according to the NASD bylaws, we agreed under Article 1001, it's actually in your materials, it says as a condition of membership, you agreed to the arbitration of all disputes with public customers. And they said, hey, but she's not a public customer, she's not our customer. So of course, we had to file a response and we went through the whole litigation process. And we argued to the court, like in the Vestax case, like in the John Hancock case, that it's not whether she's a customer, it's whether or not her claim arises from the supervision of the broker. There's Multi-Financial was supposed to be watching their broker. It arises in connection with the broker's business because the broker is holding himself out to the public as one of their agents. It arises in connection with their duty to supervise the broker. So the court said, you're going to get to go to arbitration. We settled that case at the Third Circuit. We were literally upstairs on the 21st floor of the Third Circuit, moments before the appeals would be filed, and we settled that case. There was a companion case, a larger case involving a group of doctors, and that case was settled too. But as you'll see, in the selling away case, that's when you have a broker engaging in extracurricular activities. When brokers do things that they're not authorized to do by their employers and they engage in the sale of unregistered securities, that claim is called selling away. And most brokerage firms love selling away cases, particularly in court, because in court, the judge may have determined that as a matter of law, number one, we have failed to show or could not prove justifiable reliance. We can't, well, that's a question of fact, but more like apparent authority, or that we can't